2022. The bill repeals, and I'm talking about the Strike and Insert Amendment, Chapter 20, Article 2, Section 6A, and it amends numerous sections, amends and reenacts several sections in Chapter 61, Article 7, and in that regard, there is and the Strike and Insert Amendment creates 3 new sections. There are some differences between the Senate Strike and Insert Amendment and the House bill in terms of the sections included in the bill. 6177 is in the Senate Strike and Insert, but not in the original House bill. The original House bill provides that anyone over the age of 21 can possess a firearm and carry it concealed deadly weapon without having to have a permit to do so. And the Senate Judiciary Strike and Insert preserves that. In fact, and I'll talk about that in a little more detail, but we expressly say it in the Strike and Insert, whereas the House bill did not. The bill makes several amendments to existing permit procedures. So in the bill, we're preserving a concealed carry permit, that process as it exists in our current law, both the House bill and the Strike and Insert Judiciary Amendment, but we make changes to it. The bill creates a provisional license program for people who are at least 18 years of age, but less than 21 years of age. And the bill amends numerous other provisions of the Deadly Weapons Article of the Code. Okay, the provision that's repealed, the section that's repealed, 20, Article 2, Section 6A, that's a section in current law that allows anyone to carry a concealed handgun for self-defense purposes while afield hunting, hiking, camping, or in a motor vehicle. It's deleted because, if this bill passes, that's unnecessary. People would not be limited to those purposes or circumstances in when they can carry a concealed gun. Under Section 3, Article 7, Chapter 61, the bill makes it a misdemeanor offense for anybody who's under the age of 21 or is prohibited from possessing firearms under Section 7 who carries concealed deadly weapon without a permit. Now, under current law, it's a misdemeanor for any person to do such an act. The Strike and Insert Amendment, adopted by the Senate Judiciary Committee, ramps up penalties for that. And I'm going to come back to that later because there's going to be a technical floor amendment that addresses part of that. But they're ramped up penalties. And let me just depart from the rigid section-by-section discussion of this to say that in an effort to do 2 things. Give life to the right of people to keep and bear arms, which is guaranteed in the federal and state constitution. The bill relieves people over the age of 21 from having to have a permit. But to address the concerns that were made by law enforcement and others, what we've done is we've ramped up, and I'll discuss them in a minute, some penalties and have created new offenses to deal with bad guys who have guns, people who aren't supposed to have guns who do. Under Section 4, there's a requirement added that a permit applicant be a United States citizen or legal resident and a resident of West Virginia, the county in which the application is submitted. Now, under current law, the applicant need only be a resident of West Virginia and the county in which the application is submitted. So that is part of our Strike and Insert Amendment. Under Section 4D4, the bill requires that any certification of training submitted to acquire a permit include the instructor's name, signature, and NRA or state instructor identification number. One of the concerns that law enforcement expressed to us that we tried to address in this measure is that they don't know the validity. They're not able to tell the validity of the people who are doing these certifications of training. So this is a part of that that's designed to address that. Under Section 4H, requires that all duplicate license cards are to be uniform across all 55 counties of the state. Uniform in size, appearance, and information, and feature a photograph of the license. So, and this duplicate license card is to be designed and prepared in cooperation between the state police and the West Virginia Sheriff's Bureau of Professional Standards. So, as members know, we have 55 counties in the state, and there is right now, and this was another of those issues that was raised by law enforcement with whom we worked and negotiated and tried to develop aspects of this bill to make it better. So there would be a uniformity in the card that people are issued when they have these concealed carry permits. Under Section 4R, the House bill that came to us had a tax credit in it. And the Senate Judiciary Strike and Insert Amendment eliminates that completely. Not because we think thought it was a bad idea, but rather that when we started to discuss this with the chairman of the House Finance Committee, we realized that it could blow a several million-dollar hole annually in the state's general revenue budget. So that the House bills that came to us, which had that tax credit in it, that was stricken by the Senate Judiciary Committee. The bill creates Section 6174A, which is newly proposed, and it provides for the provisional license for people who are 18 to 21. The requirements and procedures for this provisional license under this section are the same as for obtaining a regular license. However, the application fee for the provisional license is only $15, reduced. Section 6 in Article 7 provides for exceptions to the prohibitions regarding carrying concealed deadly weapons. There's a new subsection C regarding a Law Enforcement Safety Act. That was in the House bill. The Senate Judiciary Committee stripped that from the bill for the reason that, one, we thought there were some technical problems with it, but two, we've already passed the bill. Do you remember the bill number? We passed Senate Bill 201, which addresses all those things already. The Senate has, and that bill is in possession of the House, and it wasn't necessary to any of the sections that are in this House Bill 4145 or the strike and insert. Okay. The bill, as it was passed by the House, did not amend Section 7 of the Dangerous Weapons Act. Our strike and insert amendment does. First of all, it makes it clear in black and white language that anyone over the age of 21 who's not prohibited by law from having a firearm is permitted to carry concealed without a permit. It also defines new offenses. We define a new offense, make it a felony to carry a concealed deadly weapon by anybody who's prohibited under Section A from having a deadly weapon. Anybody who's prohibited by federal law or state law from having firearms. It's a felony punishable by up to 3 years in prison, a fine of up to $5,000. It also provides that anyone who's prohibited by subsection B is guilty of a felony, and that's a 10-year felony, and it's up to $10,000. And that's somebody who's convicted of a felony as a result of a crime of violence, convicted of a violent felony, or certain drug offenses. And so what we're doing, if we adopt this, is we're saying, look, while law-abiding citizens have the right, they clearly have the right, and it's a right enshrined by the Constitution, to have weapons, to carry them concealed. If a person who is prohibited by law from having weapons straps one on, carries it concealed, he or she is going to prison for a very long time. That was our effort on that. And I think that's the distinction we need to be drawn in this. Section 11A2B provides exceptions for the prohibition of possessing firearms on school buses, education facilities. The bill adds probation officers to the list of exemptions. In other words, the bill, if we adopt it, will allow courts' probation officers to carry their weapons onto school properties. We create a new section. This is in the House bill and the Senate Judiciary Strike and Insert, Section 15A, which provides enhanced penalties for the use of a firearm during the commission of a felony. So we're ramping up the penalties on those. The Senate Judiciary Strike and Insert says that it's a felony for any person who uses or presents a firearm during the commission of a felony, which is punishable by up to 10 years in prison. And these new offenses that we're describing and laying out make clear, or try to, that they are in addition to any and every other offense that could be prosecuted under the provisions of the state code. We had a new section 17 which provides for construction of the article, and it's very short. It says that nothing in the article shall be construed. Let me get to it. I'll read it. It doesn't take very long. Nothing in the article will be construed to abrogate or modify the statutory provisions and common law decisions related to defense of self or others. So we always want to do that. This legislature, prior to my arrival here, but has passed some self-defense, castle doctrine, they go by various names, laws in certain areas. There's a whole body of common law jurisprudence been developed over centuries relating to the right of people to use a firearm to defend themselves or others. And all that does, that language is designed to make clear we're not trying to alter any of that. So that's sort of a rough outline of what the original House bill did and the Judiciary Strike and Insert Amendment. And I know or believe there are going to be amendments offered to this amendment, but I will pause there, Mr. President, and yield for questions or others to join the discussion.
Clerk has an amendment to the amendment.
Senator Stallings moved to amend the amendment on page 1, section 3.
Senator from Boone.
Unanimous consent to explain the amendment in lieu of having it read.
Senator from Boone requests unanimous consent to explain amendments in lieu of having them read, and that all the amendments be considered as one as their objection. Chair hears none, so ordered. Senator from Boone.
Thank you, Mr. President. This amendment basically would require a citizen of West Virginia to present a valid ID to the sheriff's office of someone that's over 21 and pay a $5 lifetime fee. So for $5 you would have the ability, if you're a West Virginia resident over 21, to carry concealed. The idea is to limit this to West Virginians. I think there's been a lot of discussion over that, and I urge adoption of the amendment to the amendment.
Is there discussion? Senator from Morgan.
Would the distinguished gentleman from Boone yield?
Well, Senator from Boone yields. Senator yields.
Thank you. To my distinguished colleague from Boone, let me ask, because I'm not sure I understand, in your amendment, does that replace the entire permit structure now?
No, sir. All it does, it would keep all that you have in your strike and insert, including the full-fledged, after you take the training and the one that you'd have reciprocity with. This just simply says that people over 21 in West Virginia that could otherwise carry a gun can carry concealed with a one-time $5 fee in showing your ID.
For purposes of obtaining that permit, they still have to go through what current law provides for a permit, training and all that? Is that?
No, sir. No training whatsoever, no added, it just simply shows that you're a West Virginian, and that because of the paperwork, I guess perhaps, that you would have some type of form that says basically you're a residency exception concealed carry permit. And all you have to have is $5 and a West Virginia ID and be over 21 years old.
Okay, I think I understand you, ma'am. Thank you.
Senator from Upshur.
Thank you, Mr. President. I would rise in opposition to the gentleman's amendment, and I'll explain a few reasons perhaps why. One, I believe that it actually, as have been many attempts, turns this proposed law on its head. We're recognizing the constitutional rights of West Virginians, and those rights exist for people from other states as well to carry a firearm. That's a right that's recognized and guaranteed by the Second Amendment to the United States Constitution. It's recognized and put into our state constitution in Article 3, Section 22. In addition, I believe that the amendment raises constitutional questions that have been addressed in committee. As our committee counsel explained to us while we were discussing this in judiciary, there are some questions that are really raised from a constitutional perspective. By doing this, we have the possibility that we're setting a double standard in terms of the law, what people from outside the state of West Virginia have to comply with and people inside the state of West Virginia have to comply with. Now, we can do this in some areas, and it's recognized that, for example, with a hunting license, we can set a differential because those are state resources, and the courts have long held that because the state owns those resources and manages those resources, that the residents of the state can pay a lower fee for a license. And the same thing is true with our 4-year and 2-year institutions, that we can have in-state tuition that's lower than out-of-state tuition and so on. But that's because there's a compelling interest that the state has in the resources that are being, in one manner or another, licensed for use. This is not a resource. This is simply a right. And so to try to put a fee on exercising a right when there's no compelling interest by the state in terms of being able to show that the state in one manner or another has put resources into simply exercising that right, leaves the same question open as to whether we did this with or without this special license. I don't think that it resolves that question at all, and so it still, I believe, very much would be found to be unconstitutional. Some additional problems that it has, it does still essentially function as a concealed carry license, and we're trying to get rid of that. We're trying to recognize this Second Amendment right, but this would be a license that you would still be required to carry, presumably for your entire life, even though the fee is only $5. If you lose it or you don't happen to have it, I assume that there would be some type of charge possibility, some type of a crime could be charged against you if you don't have your license on you at the particular time. So again, it defeats the purpose of this bill. It's still a license. I didn't hear in the explanation, and perhaps the senator from Boone could expound on this, but if a person who's 21 years old goes and buys this license and then they move out of state, is this lifetime license still apply even if you're a resident of Texas for 20 years? Can you come back and exercise this right because you have your little license that you paid $5 for? I don't think it answers that question. And it could be not somebody from Texas, it could be somebody from the greatly feared Detroit area. So a drug dealer could come down here, buy their $5 card, and then move back to Detroit, and they would have their little $5 card. They would still be legal to carry in the state of West Virginia, according to what I understand of this amendment. So it doesn't even solve the issue that it purports to solve, I don't believe. I believe that it creates problems for reciprocity. When we start talking about reciprocity, many states have within their code, just as we do within our code, particular provisions as laid out that they will only recognize the license, a concealed carry license, from another state if it meets particular definitions. And this could create a lot of confusion because we would have these many different layers of concealed carry. I think we would have West Virginians going to other states with their $5 card thinking that they were legal to carry anywhere in the country. After all, they have their concealed carry license. So we could find West Virginians being arrested and charged with crimes in other states because of the confusion that could be created here. But then we also have the additional possibility that the reciprocity agreements that we have with about 3/5 of the states around this country, is that last number I heard, are those states going to continue to honor their reciprocity agreement whenever they see that we have a license that no longer meets the standards that they require us to meet in order to have the reciprocity agreement? So I think this amendment has constitutional questions. I think it defeats the purpose of the bill. I think it can confuse and cause West Virginians to be arrested outside the state of West Virginia for concealed carry without a license. And I think it could throw into turmoil our own reciprocity agreements with states around the country. And for that reason, I would urge the rejection of the amendment.
Is there further discussion? Senator from Morgan.
Thank you, Mr. President. I also rise in opposition to the amendment offered by my distinguished colleague from Boone County. You know, when we gabbled in this morning, what was going on right now, may still be going on, maybe it's over now, was the funeral mass for Justice Scalia at the Shrine of the National Conception in Washington, D.C. And so it's hard for me to think about this or talk about any of these issues without thinking about him. and his service on the court and his decisions, including those related to this issue, firearms. He was, in my opinion, the greatest jurist ever in the history of this republic to sit on the Supreme Court bench. In the Heller case, in 2008, he discussed the Second Amendment. We talk about the right to keep and bear arms granted under our Constitution. Well, it's not granted under our Constitution. The Second Amendment to the United States Constitution does discuss the right to keep and bear arms, but as Gentleman from Upshur pointed out on the floor the other day, and as Justice Scalia said in the Heller decision, we put the cite in the record, 478, Fed 3rd, 370, affirmed. Justice Scalia talked about the Second Amendment, and he said, we find that the elements of the Second Amendment together guarantee the individual right to possess and carry weapons in the case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendment, codified a pre-existing right. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it shall not be infringed. In other words, it's a right, it's a human right. It's a right of every American, and it doesn't come from the Constitution. What the Constitution did is said nobody can infringe upon it. So our bill, you know, if you think about it, what other fundamental constitutional right is there that we have for which we have to pay money to the government to exercise? Even if it's only $5, and I understand the $5 is $5. The purpose of this bill, one of the purposes of this bill, is to give life to the right that exists. It's a right you don't have to pay for, right? We don't pay money to go vote. That was tried in places and ruled to be unconstitutional, to make people pay to be able to vote, or to speak freely, to engage in debate, to chase their legislators and petition for redress of their grievances. These fundamental constitutional rights exist. They're guaranteed in the Constitution. And the citizens of this state are not required to pay the government to have their constitutional rights, even if it's only $5. I urge rejection of the Senator's amendment.
Is there further discussion? Recognize the Senator from Boone to close.
Thank you, Mr. President. And again, those points are well taken. There's certainly no attempt to tramp on the Second Amendment right. This was simply a goal to have this be West Virginians being able to carry. I have a lifetime hunting and fishing license here that I've carried since 3/12/1990. I think the $5 is simply to be able to produce the document. Otherwise, I urge you to vote for the amendment. Thank you.
The question is on the adoption of the amendments to the amendment offered by the Senator from Boone. All those in favor will say aye. Aye. Those opposed will say no. No. The noes appear to have it. The noes do have it. I declare the amendment rejected. Clerk has another amendment to the amendment.
Senator Romano moved to amend the amendment on page 1, section 3,
Senator from
subsection.
Harrison.
Mr. President, I request unanimous consent to explain the amendment in lieu of having it read.
Senator from Harrison requests unanimous consent to explain the amendments in lieu of having them read, and that all the amendments be considered as one. Is there objection? Chair hears none. So ordered. Senator from Harrison.
Ladies and gentlemen, my amendment is very simple. It limits this privilege, this exercise of a constitutional right in this state, to bona fide citizens of this state. I ask you to use your common sense. We've considered other amendments to to this bill. As you all know, I'm a stalwart Second Amendment advocate. I'm a gun owner. I have a concealed weapons permit. But we have to exercise common sense. And this is simply a measure that will cost no more, will not impede our citizens from carrying concealed weapons without a permit. But what it does stop is people walking across our border, the borders that we cannot cross and carry without a permit, and prevents them from taking advantage of our law. This is a constitutional amendment, and I would urge you to vote it, to exercise some common sense in this bill we're about to pass.
Is there discussion? Senator from Morgan.
Thank you, Mr. President. I rise in opposition to the gentleman's amendment. This was, I believe, considered in our committee deliberations and rejected by the committee. There's a certain inherent appeal to the sound of it, but it is problematic for a couple of reasons. One is that based on the scholarship of our staff at the Judiciary Committee and the GO Committee and others, I've come to believe that it violates the Privileges and Immunities Clause of the United States Constitution. That's found in Article 4 of our United States Constitution, and it provides that the privileges and immunities available to the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So if you think about it in the context of what we're talking about right now, what it would mean is that a person who lives in West Virginia may do something in West Virginia that any other person is guilty of a crime if he does it, if he or she does it. So if a member of this body has a brother who lives in Virginia who comes to West Virginia to visit for a day, he couldn't carry if the gentleman's amendment is adopted. But if he comes one day and lays down a deposit on his lease, his apartment, then he can. It's a distinction that makes no sense. If this is adopted, what it will mean is West Virginia citizens are being given immunity for something that is a crime for conduct conducted by a person who lives in any other state in the United States. So in that sense, I believe it would violate the Privileges and Immunities Clause of the United States Constitution. And we've been scouring Westlaw and Nexus and Lexis for cases precisely on point, and there aren't any. We haven't found one yet. We may, because as we know, we're moving toward 7 or 8 states now which have adopted permitless carry statutes, concealed carry, some of which have, and I will concede it because I know if I don't, the gentleman from Harrison County is going to get up and ask me anyway. Some of the states have tried to impose those requirements, that the limitations to residents only. But so far as we can tell, none of those has, in the context of a court challenge, been framed up and worked its way through the court system yet. So to date, we've been unable to find any case precisely on point. The privileges and immunities jurisprudence cases we've read say there has to be a compelling state interest, and that was discussed earlier briefly when in the context of how we justify having a differential in the price for like a non-resident hunting license and a residence hunting license. Non-residents cost more. Or how it is that it's legal to charge more for an out-of-state student who attends West Virginia University than an in-state student. And the answer invariably given by the courts in those cases is that it's not a violation of the Privileges and Immunities Clause because the citizens of the state are providing their own resources, in the case of our higher education institutions, money, tax dollars that the citizens pay to support those, that justifies charging more to citizens who don't pay those, non-residents. In the context of hunting licenses, that sort of thing, they're natural resources that belong to the citizens of the state, not a right belonging to an individual, a natural resource belonging to the people of the state and supported generally with the state's tax revenues that justifies a differential in price. Here we're talking about a fundamental constitutional right that belongs not just to the citizens of West Virginia, but to everyone. To everyone. So I urge rejection of the gentleman's amendment.
Is there further discussion? Further discussion. Does the Senate recognize the Senator from Harrison to close?
Thank you, Mr. President. You know, we're great hypocrites here. We pass laws that put women's lives at risk, laws that are clearly unconstitutional in other states. We're passing laws that take away West Virginians' right to keep and secure their own property. But we're worried that no other state has had a challenge or found absolutely constitutional the right to exclude out-of-staters from a permitless concealed carry. It is the law in Wyoming. It is the law in Wyoming. You cannot be an out-of-stater and carry permitless in that state. You know why? Because it's common sense. There's a whole bunch of responsibilities they put on permitless carry in the other states. We adopted almost none of them. But you know, it's already the law in West Virginia that unless a cousin from Virginia has a permit, that they cannot carry in this state. We cannot carry in 20-some other states with our permit. So they've already had restrictions on all out-of-staters bearing arms. Now, with all due respect to my esteemed colleague from Oregon, who I have the greatest confidence in, the United States Supreme Court said in the case of Robertson versus Baldwin in 1897, the right of the people to keep and bear arms is not infringed by laws prohibiting the carry of concealed weapons. Justice Scalia said, the right secured by the Second Amendment is not unlimited, and that the right is not a right to keep and carry any weapons whatsoever in any manner whatsoever and for whatever purposes. That was Justice Scalia. I'm not trying to stop permitless carry. I would have liked to have seen some more common sense injected into it. The majority didn't believe that was appropriate for whatever reasons. But this is a common sense amendment to this bill. If you noticed in the paper today, 7 people were arrested down in Huntington on drug charges. Out of those 7, 4 of them were from Columbus, Ohio. They didn't have a record. They could carry a concealed weapon under this law. If the police officer who found the concealed weapons in the folks from Columbus, Ohio's belt or in their car, they would not be able to look in the trunk to see if there were drugs. If there was contraband being brought into our state to sell to our kids, to sell to our neighbors and our friends. And the result is going to be every person who comes across that border is going to have a gun in their belt. Common sense. I urge you to vote for this amendment. I urge you to move forward and let's get off of this business and try to attend to the business of the state. Thank you.
Questions on adoption of the amendments to the amendment offered by the Senator from Harrison? All those in favor will say aye. Aye. Those opposed will say no. Noes appear to have it. The noes do have it. I declare the amendments rejected. The clerk has another amendment to the amendment.
Senator Trump moved to amend the amendment on page 19, section 7,
Senator
line
Morgan.
60.
Thank you, Mr. President. I ask unanimous consent to be able to explain this amendment and have it be considered as a single amendment in lieu of having it read.
Senator from Oregon requests unanimous consent to explain the amendments in lieu of having them read and that all the amendments be considered as one. Is there objection? Chair hears none, so ordered. The Senator from Oregon.
Thank you, Mr. President, and my apologies to the membership and the committee. This one got away from me. I should have caught this in committee. This amendment is keyed to Section 7, Article 7 that we pull into the bill. That's the section of the code that delineates who are prohibited people, who's not allowed to have, carry, possess a firearm in West Virginia. And in that, in an effort to make it clear that we're going to be serious and deal seriously with anybody who is prohibited by law from having a gun, we define new offenses. And the way it was worded as we reported it out, the Senate Judiciary Committee, I'll just read you subsection D. It says, as a separate and additional offense to the offense provided in subsection A, and in addition to any other offenses outlined in this code, etc., any person prohibited by subsection A from possessing a firearm who carries a concealed deadly weapon is guilty of a felony, etc. It's 3 years in prison. This amendment will change the word deadly weapon to firearm, so that we're not making a 3 and 5 year, 3 year and 10 year felonies for somebody who has a pocket knife in his pocket. These new offenses apply to prohibited people who have firearms. I urge adoption.
Is there discussion? If not, the question is on the adoption of the amendments offered by the senator from Morgan. All those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it. Declare the amendments adopted. Is there further discussion on the amendment offered by the Committee on the Judiciary as amended? If not, the question is on the adoption of the amendment offered by the Committee on the Judiciary as amended. All those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
If not, the bill be advanced to third reading.